Hi, good evening. It's again another interesting judgment under Goods and Service Tax Act. Karnataka High Court citation is Toyota Kirloskar Motor Private Limited versus Union of India and others. Facts are very simple. Audit was conducted at the office of the Toyota Kirloskar TKML. It was noticed during the audit that tax invoices from the tax invoices that the title and risk in the goods pass to the buyer, dealers, when the goods are put on common carrier at the factory of TKML, that is Bidadi, Karnataka. So once they put the goods in the lorry, then the title and risk pass to the buyer. So then the audit department looked into the dealership agreement. From that, they concluded that the delivery of products from TKML to dealer is deemed to be complete once the products are put on the common carrier. After that, this Toyota Kirloskar, that is TKML, will not be responsible for any failure, delay or delivery, or error in delivery. Based on the above, AO came to the conclusion that the transfer of title in the products took place within the state of Karnataka. The risk and consequential loss also passed on to the buyer. But TKML was treating the sale as interstate sale and it was paying IGST. So AO issued a show cause notice treating the sale as local sale. So he demanded CGST and KGST. AO relied on the definition of delivery under the Sale of Goods Act. According to Sale of Goods Act, delivery means voluntary transfer of possession from one person to another, and when goods are said to be in a deliverable state, when they are in such a state that the buyer would, under the contract, be bound to take delivery of them. So that is the definition, simple definition. Then further, AO relied on Section 19, Section 23 of the Sale of Goods Act. They talk about when the property in the goods gets transferred to the buyer and when goods are deemed to be unconditionally appropriated to the contract. AO has made a lot of effort to bring the transaction under the KGST. Based on the above, AO issued a show cause notice, demanded CGST and KGST. You pay CGST and KGST even though you have paid IGST on the transaction, which is not applicable. If you want, you go and claim refund of IGST, you pay CGST and KGST. That was the demand by way of a show cause notice. This was challenged by the TKML by way of a writ petition. Karnataka High Court said that a plain reading of Section 10(1)(a) of the IGST Act will indicate that where supply of goods involves movement of goods, whether by the supplier or by the recipient or by any other person, that is common carrier, the place of supply of goods shall be the location of the goods at the time at which the movement of the goods terminates for delivery to the recipient. So this is very important. The last words, for delivery to the recipient. So court said it follows therefrom that the movement of the goods terminates for the purpose of handing over delivery to the recipient and to enable the recipient to take delivery of the goods, not when the goods are handed over to the common carrier, but only when the goods reach the destination for the purpose of enabling the recipient to obtain or take delivery, as is clear from the aforesaid provision. Simply put, when it is put on the common carrier, it is not taking delivery. Only when it reaches the destination, he can take delivery of the goods. The delivery gets completed only at the hands of the recipient in the other state. That is what it is saying. So court said, notwithstanding the fact that the TKML had not handed over the goods to the common carrier. I think that is a typographical error because it cannot be had not. because both the facts, as per the facts accepted by the TKML and also by the department, is the goods were handed over to the common carrier by TKML. So that not is a typographical error. So the fact that TKML handed over the goods to the common carrier for the purpose of delivery to the ultimate destination, liability to pay IGST under section 10(1)(a) would arise only upon the movement of the goods terminating for delivery to the recipient at various places outside Karnataka. Undisputably, undisputedly, the supply of goods is interstate supply and not intrastate supply so as to attract CGST or KGST. The contention of the department based on the provisions of the Sale of Goods Act, tax invoice agreements, etc., all of them were rejected by the court. The court said that the place of supply of goods would have to be determined by reckoning or considering the place where the movement of goods terminates for delivery to the recipient and not at the place where the movement of goods originates when the goods are handed over to the common carrier, especially in the light of the undisputed fact that the ultimate destination where the movement of goods terminates for delivery to the recipient is outside Karnataka. That is, you don't need the movement commences when it is handed over to the common carrier. So delivery is not complete at that time. The movement ends only when delivery is taken by the recipient at the places which are outside the state of Karnataka. Hence, according to the court, delivery is not complete when it is handed over to the common carrier. That is what the court says. Karnataka High Court said that there is no nexus or connection whatsoever. This is very, very important. There is no nexus or connection whatsoever between passing of title to the goods from TKML to the dealers by virtue of the terms and conditions of the dealership agreement, invoice, etc. The liability to pay IGST will arise only when the place of supply of goods would be the place of the recipient, the place of the as per section 10(1)(a), the liability to pay IGST arises when the place of supply of goods would be the place of the recipient when the movement of goods terminates for delivery to the recipient. So that is the crux. When the movement of goods terminates for delivery to the recipient. On that basis only IGST. It is not locally it is delivered. That is the view of the Karnataka High Court. Further, the court said the petitioner has already paid IGST not only for the goods but also for the freight charges, and any additional amount sought to be demanded from the petitioner would amount to double taxation. So, non-payment of KGST or CGST would lead to revenue neutral situation, which would not cause any prejudice or hardship to the department. That is the view of the court. On that basis, Honorable High Court quashed the show-cause notice, saying that it is arbitrary and illegal. I have my own comments on this judgment. One, can a court, High Court, under exercising power under Article 226, interfere at the stage of show-cause notice in case of such types of questions? Because it has been the consistent view of the Supreme Court, only in case of violation of principles of natural justice, only in case of, even though these are all not restrictions, only in case of the jurisdictional issues, or you are challenging the provisions of the Act. On these grounds, you can approach the High Court. Even though Supreme Court said no, it is not a fetter, court can always consider and exercise its power. But is this a case fit for exercising power under Article 226? Is one of the questions which I think, I don't know, I'm not sure. Court is all powerful. But whether this, on the facts of this case, whether court could have quashed the show cause notice, that is point number one. Point number two, according to me, crucial words in the section are N1A IGST Act. Place of goods, place of supply of goods shall be the location of the goods at the time at which the movement of the goods terminates for delivery to the recipient. So, very, very important words are at the time at which the movement of goods terminates for delivery to the recipient. In the present case, taking into account the facts of the case, a view can be taken that if the dealer wanted, you could have sold the goods within Karnataka also, because title and property passed to the dealer once the goods are placed on the common carrier. So, in case if he wanted, assuming that he wanted to sell the goods within Karnataka, he could have sold it because it is his goods. So, the movement of the goods terminates for delivery to the recipient is within the state of Karnataka. That view, that point of view can be taken by somebody. Even though the Act says, it is not saying that clearly that movement is there, is it inextricably connected or not? Those were the issues under the previous Sales Tax Act. So that is not there. The movement is inextricably connected, so that it is an interstate sale. That is not there. Nowhere I am getting a finding of fact on that. So on that basis, a view can be taken that delivery to the recipient is complete once the goods are handed over to the common carrier. A view may be taken. In such a case, naturally IGST will not be applicable. Only CGST or SGST will be applicable. The authorities can say the subsequent movement is the movement of the recipient. Once it is loaded onto the common carrier, delivery to the recipient is complete. The movement by the recipient, after that the movement is by the recipient from Karnataka to his own to other states outside the state of Karnataka. That view can also possibly be taken by the authorities. Third is those who are planning to sell their old sales tax case books. I had recently I put it to the because want of space, so all the books were put to the paper wala, old paper wala. Now I think I committed a mistake. So if you keep on to the books, keep on all those things, because in the earlier sales tax laws, the one of the questions were whether it is interstate sale or local sale, and one of the very famous cases was Ashok Leyland versus Union of India. Uh, my senior only argued that case. Of course, the senior appeared for my senior was Parasaran sir. So thank you very much. Have a great evening. Bye.